you continue to go down the hill. So the entire hill just goes down. So the canopy would be above the house. So it's kind of like up the hill a little bit. I brought some pictures too, or however that helps. See, that's where the canopy's gonna
Do you want another copy?
be. I have these.
Oh.
Yeah,
They're not as
actually,
pretty.
these were just submitted to the zoning office at 3 o'clock this
Yeah.
afternoon. We can print them out.
I didn't get a
colored, so
chance.
do you have other ones?
Yeah,
Colored?
she has the colored ones.
Oh, okay.
So we can pass those around.
So the downhill part is that they would be looking at the array.
I mean, they're still gonna be looking at it because when you walk outside the house, it's right here, right in front of you. Right here. So the canopy's gonna be here. So the canopy's gonna be here, and the house is down here, so this goes downhill. So it starts out and goes in.
And this is adjacent property?
No, we got this from like Google Earth, and it kind of does that thing if you zoom in too much with the trees. The adjacent property is 363 feet in the other direction, 271 feet, and then 250 feet.
Oh,
So they're pretty far away.
Can the other properties see this array?
No. So the pictures I submitted to you have here in color. This is where the array location is going to be, is on the first page.
Yeah.
This is the view from the road, or the driveway.
All right, what do we?
So this is their driveway, and then back here is the house, and directly through the woods here is where the canopy is going to be. And then this would be viewing east towards the house. That's east, and then it's 252 feet.
How close is will this be seen by our neighbor?
No.
And
This is the view
where
south.
they go from.
Pardon me?
So this is where, that's the driveway coming in. So it's gonna be blocked out completely. Here, and that's
What's this area right here?
I think it's just their,
Is it a garden or something?
that's their garden. I think that's just a yard that they cleared. There's nothing over here.
All right. One of the things that our consultant brought up is on your sheet PV03, you show the canopy racking detail. It looks like the array is going to extend over the roof. In other words, the array is going to be closer to the road than the canopy?
No. I think that just kind of, so here's a
See what
copy.
I'm talking about, right? That one right there.
Yeah, I think this may help. These are what the canopies actually look like. So I think what that is, because the panels are not actually longer than these. They're smaller. They fit between here and here, because this is the strongest part of the canopy.
It'll fit between the rafters.
Yeah, it fits right on here. They don't overhang. This part is the only part that overhangs.
Thank you.
So it actually, the panels become the roof.
Is there going to be any other equipment visible from the outside other than the array?
No. The batteries are, here, that's where
Oh.
the batteries are going to be, I'm pretty sure inside the basement. They're going to be in the west interior garage wall, the 3 batteries, so everything will
That's
be
what
inside.
those red rectangles are?
Yep. You see here, west interior garage wall will be the 3 panels.
Now, under the town code, there's a limitation of 110%, which provides that the system shall be limited to a power generating capacity not in excess of 110% of the anticipated annual total amount of electric energy. Our consultant is suggesting that we get a letter from a licensed engineer or other qualified professional saying that you're not going to exceed the 110%.
Yeah, we can get that.
That's required in the code.
Yep.
You sized it based on that? Yes, okay.
Yeah, because even when you submit for a NYSERDA grant through New York State, your NYSERDA grant you can't produce more than 110% of what you actually use. Otherwise, NYSERDA won't grant you the New York State grant for your solar. So I can definitely get a letter for you guys.
One of the things that I saw is we never got a survey for the property. Our application package requires a survey to come in, but it's not required under the code. If we feel comfortable enough with what they're supplying to us, we can waive that requirement. Something for you to think about.
I would want to double check with legal counsel on that.
Kyle's
When I
here.
found- Yeah, so, yeah, what I found is exactly what you said. It's on the checklist, but it's not in the code, so that I would think that it would depend on, ZBA's established practice, whether you're inclined to waive the survey if you find that you have sufficient information. But I would want to make sure that there's nothing, legally that would incline you one way or the other.
Okay, thanks, Alicia. Alright. So really what we're looking at here is the front yard setback under the code is 75 feet. This new canopy is going to be 56 feet off the front. So they need a variance of 19 feet. That's what the application is calling for.
Maybe it's Kate, you have that?
I did.
The parcel access?
I'm looking at it. Oh, there you go.
Here you go, Kyle. While Kyle's looking at that, maybe we could look at some of the criteria for the variance. We have to decide whether there will be an undesirable change produced in the character of the neighborhood or detriment to nearby properties. From that parcel access, it doesn't appear as though the array is going to be seen by any of the neighbors. It is well screened with trees and brush. I don't see any undesirable change or detriment to the neighborhood. Anybody else have any thoughts on that?
Now where the location is with it. No.
Yeah, I don't see any issue. So it's downhill from the properties to the north?
Which way is north on this? Is it up?
That's,
Good question.
Open very far. Yeah, it's just northwest, southeast. Yeah.
North is at
Yeah,
that
yeah,
point.
this way.
And we have to look at whether the applicant has any other reasonable method to place the array. And I think that the evidence that's being presented to us is there isn't another reasonable spot on the lot due to topography. It seems like that's probably the only place it could be. And we have to look at whether the variance is substantial. 19 feet with a 75-foot setback, I don't think that's going to be considered substantial, in my opinion anyway. I don't see any adverse effect on the environment. It is a self-created hardship, but I don't think that's not a make or break item or criteria. Does anybody have any thoughts on any of the criteria or any questions you may have of the applicant?
no, it seems to be the best place to put it. I mean, this is just a berm of rock. That's what this is.
Yeah, just grass that they don't mow.
Behind. behind a bunch of trees. It seems like there's brush from the road that stays all year long,
Mhm.
so you don't see it in the winter.
And I'm pretty sure that's their only driveway. No one else uses it, so those would be the only ones going down that road.
Yeah, I don't think 19 feet is substantial in this location either.
And just sorry, this vegetation here,
We're not touching that. That's staying. This
Right.
is all staying.
but this is deciduous, right?
Pretty sure, but I can double check.
Yeah, and the road is along here.
Well, it goes like here, like another 20 feet, and then it stops. So it goes,
Okay.
but nobody goes past here, so it just turn into their driveway.
It's a dead end.
Yeah.
And the way that the orientation is, it's facing away from the road anyway. So,
What do you think, Kyle?
Well, I think in terms of the survey, it's pretty far back from what appears to be what the property line would be, so I don't think there's any question. It's on there. It's on the subject property.
Right.
I don't see any issues with it.
And you've supplied measurements to us as far as the distance from the front yard setback,
Mhm.
front yard, side yard, rear yard.
Yeah.
You've given us all those numbers.
It's on page 2.
How were you able to determine those values? Did you look at a survey or was the property staked?
We have a solar evaluator that goes out, and he walks it to the property lines.
Oh, okay.
When he puts in the stakes of where we want it to go, so we can have accurate measurements for you guys. Because most of our ground mounts always go to planning.
Well, I think based upon what they've supplied, I don't think we really need to assist on the survey. We have waived it in the past for simple applications. Does anybody have any thoughts on that?
I agree.
I don't know what the survey is gonna tell us.
Yeah, I think it's a waste of time to make the applicant do it, so I think, I'm comfortable with what they've supplied, so. All right. Let's do a couple things. First, I think we've got to look at seeker. This is a type 2 action under seeker, so I would make a motion that we declare this application to be type 2 under the State Environmental Quality Review Act. Do I have a second? All in favor?
Aye.
Okay. I'll make a motion that we grant a 19-foot front yard setback variance on the condition that prior to the issuance of a building permit, the applicant provide us with a letter from a licensed engineer or qualified professional or the installer of the solar energy system stating that the solar energy system will satisfy the 110% rule under Code Section 165-60E9. The motion to grant the variance is based upon an analysis of the 5 criteria under the town code and the state law. I think we've determined that there's going to be no undesirable change produced in the character of the neighborhood. There is no other reasonable, feasible place to put the array based upon the topography of the property. These variance is not deemed to be substantial under the circumstances, and there will be no adverse effect or impact on the environmental conditions in the neighborhood or zoning district. Do I have a second?
Second.
All in favor?
Aye.
Good, Carol.
I just wanted to chime in, I may have missed this, was the public hearing open and closed?
Actually-
Did you guys do the public hearing on this?
Now, actually,
You got a
I'm
second?
glad you said something. All right. Presentation. Make a motion, we open the public hearing.
Second.
All in favor?
Aye.
Anybody here wish to speak for or against the application? There being no one, I'll make a motion that we close the public hearing.
Second.
All in favor?
Aye.
All right. Alicia, do you think I have to restate the motion, or can I just refer to?
I would just take a motion just referring to what you placed on the record, if there's any changes in the votes now following the public hearing.
All right. Okay. I'd make a motion that we grant the 19-foot front yard variance based upon the evidence that's been produced here this evening and our analysis of the 5 criteria under the code, as previously stated.
Second.
All in favor?
Aye.
Motion carried. Done.
Thank you. Do you want to keep all this, or you want me to take anything?
Leave the color photos.
Yeah,
We
those.
need those.
The nice one.
Yeah,
You wanna
give us
keep all
one of those. Yeah.
And I can take these.
Have
You can
Lisa
take
put them in the
those.
file. We'll have Lisa put those in the file.
Thank you, everyone.
Thanks.
Have a great night.
Thank you.
All right.
Good night, everybody.
Thanks, Alicia. Bye-bye.
All right, bye.
All right, next we've got August Madeline Fields LLC Farm, 749 Stanford Road. There's an appeal by the applicant through its attorneys, appealing the building inspector's removal notice dated May 7, 2025, and a compliance order to remedy dated June 23, 2025. Is there anybody here for that application? Come on up. Could you state your name, please?
Hi, Alicia Leglin, attorney at Hodgson Russ. I represent the applicant.
Have a seat. It's
A
not
lot of
a-
these meetings, I've never
yeah.
done a table before. This is great.
It's not up for a public hearing this evening.
Yes.
We have to decide how we want to handle this.
Yep.
Wanted to give you an opportunity to tell us what your position is.
Yes, thank you. I appreciate that. So just a little bit of background. I know it's been several months. So the farm got a building permit back in 2024 to put up solar panels, a very small array just to power the farm. This isn't a situation where they've leased a portion to some other company who's going to be doing this commercially. This is just to power electric for the farm.
Ms. Leglin, before you get started,
Oh, sure.
let me just make sure. Did you get the correspondence I sent you on the July 29th?
Yes, I did.
Okay, so just gonna have this placed in the record
Okay.
on July 29th.
I think we'll also make a part of the record that Ms. Legland also submitted a letter dated June 13, 2025 that we're accepting into the record on this as well.
Great.
Sorry for the interruption.
No, that's okay. Thank you. Like I was saying, the array was put in after the building permit was received, 2024. The neighbors to the farm appealed, brought this to the zoning board. So the zoning board reviewed the building permit, and that was February of this year, and rescinded the building permit, and then we got a removal notice and compliance order in May of this year. One of the things that is important in this process is noting that we sent a letter to Department of Ag and Markets to get a review under Ag and Markets Law 305 to understand, which I'll get into in a second, just to understand how Ag and Markets views this local determination as far as impacting a farm operation in an ag district. So we are still awaiting Ag and Markets determination on that question. We were hoping to have it before this evening, but we still have not gotten it. So we then appealed the rescission of the building permit to this board via that letter that I sent you on June 13th. So I sent that letter in, but just to restate, for your benefit, there's a few reasons why we're appealing the rescission of the building permit, and mostly it has to do with the fact that this is a farm operation, and that is a very important distinction. This is not just a farm, it is a farm operation as that is defined under our Ag and Markets Law in a state certified, county certified agricultural district. So the reason that that's so important is because farm operations are protected from overly restrictive local laws and regulations under Section 305 of the Ag and Markets Law. So zoning laws and actions that conflict with Ag and Markets Law are superseded by the department, and the department has the authority to compel compliance with the Ag and Markets Law when certain town actions laws overreach. So we believe that the position is that this is unreasonably restricting a farm operation in an ag district, mainly because this is and this is consistent with Ag and Markets policy, is to consider, you know, a wind turbine or a small solar array that's used to power a farm to be on-farm equipment. And so this is in effect requiring a protected farm operation to get a special use permit for on-farm equipment when the farm itself doesn't require a special use permit. So it's a bit of overkill and a little bit of additional burdensome red tape that we are asking and have asked the Department of Ag and Markets to take a look at. So that's the first piece of it. We also are concerned with the consistency with the town's own comp plan and the county's ag and farmland protection plans. The comp plan, its long-term vision for the future is to protect and preserve agriculture. And, you know, that's not going to happen when it's, you know, unreasonably burdening farmers, you know, requiring a special use permit for things as simple as on-farm equipment. So, you know, this leads to, and we see this in a lot of towns, and a lot of towns have expressed concerns about development pressure on farms and farming not being economically viable anymore. And things like this are one of the reasons why farmers walk away from farming, because they're trying to diversify, make farming a little bit more economically appetizing, you know, running a small solar array to power the farm because it's tens of thousands of dollars to run a solar farm. So this contradicts the town's pro-agricultural policy. Similarly with the county's policies, the County Ag and Farmland Protection Plan, the executive summary's first sentence is that agriculture has been and continues to be one of Dutchess County's primary industry. Our economy, rural landscape, community character, environment, health of residents, and overall quality of life are uniquely and positively affected by farms operating here. It also states that the plan recognizes the challenges facing the ag industry in the county, including the high cost of farm operations like energy costs and of farmland coupled with low monetary returns. And it goes on to say that, you know, municipal officials and the local towns in the county need to understand that there has to be a balance with regulating farms in the state, in the county, excuse me. And then the last point being, the town is also in the process of trying to adopt the model right to farm law in this town, which the county has as part of its plan. And again, that is, you know, its stated purpose in the draft law itself is to protect the existence and operation of farms. And this is just, again, making farming even more difficult than it already is. So all of this to say, I just felt it was important to state, but all of this to say in the letter itself, that this town clearly supports farming. It clearly has an agricultural history. But, you know, this decision of the board has acted contrary to that, in our opinion, contrary to the stated intent and policies of this town and this county, seemingly to appease certain concerns of one landowner rather than the farm itself and the farming community here. And I would also note that one of the reasons behind the zoning board indicating that these solar panels need a special use permit is because it's non-residential, it's a farm. But, you know, as we've talked about previously, at least our client has, you know, they have farm employees that live on this property full time. This is a residence, and it's a farm. So that's just another reason and another thing that we've noted in our letter. But that's pretty much everything. I know it's a odd procedural situation, but thank you for letting us come back and talk about it, and we really appreciate that.
I have a question. Do you really think that asking the farm to go get site plan approval and a special use permit is all that onerous?
Typically, based on Ag and Markets policy, farms are not required to get special use permits. That's considered a little bit over the line as far as what's typical. Site plan, expedited site plan, typically the department sees as reasonable. Special use permit usually is not seen as a reasonable thing for a farm. And a farm operation in a certified ag district like this one is.
Why not apply for the site plan approval then?
Well, this is for the special use permit, this is what is being required, so,
Good. Thank you.
yeah,
Thanks
thank
for
you.
the presentation.
Thank you.
Anybody else that wants to speak on this?
Well, we're not having a public hearing, so.
Right.
Well, the only thing, if I may, Mr. Chair, so, I think what the understanding was we've had obviously
The
the
applicant.
applicant's counsel, and I would respectfully suggest that we allow, the neighbors' council also, to address the board, since they are the ones that began the underlying resolution. That's, the subject of their application.
Yeah, because it's just on for discussion with the attorneys, not a public hearing.
Correct.
All right, thank you very much.
Yes.
Thank you, Chair.
Go back and have,
Sure.
replace, okay. And I would also I wanted to mention before I step back,
Mhm.
I think it would be really helpful to understand Ag and Market's position on this, potentially before this board makes a decision. I don't think, it's certainly not necessary, but I do think it would be helpful for, to understand Ag and Market's position, and we're still awaiting that,
Okay.
so.
Well, we made our decision in February.
Yeah.
You understand that?
No, I understand,
Okay.
but as far as, reconsidering it, today.
Thank you.
Thank
Thank
you.
you very much. State your name for the record, please.
Good evening, Charles Gottlieb. I am Land Use Counsel from Whiteman, Osterman, and Hanna in Albany, New York. Here on behalf of Lisa Biazzi and Lou Casciano, the neighbors who initiated this whole process in this appeal. A few things just to first clarify what we just heard. We heard a lot about the farm. We didn't hear a lot about the other residential structures, whole very large residential structures, which we learned through the prior hearing. Some may be for farm employees, but I think it's also used as a rental property and other such things. So it is our position in our July 8th letter to this board that this appeal is barred by the doctrine of administrative res judicata, meaning we've already decided this matter. This Ag and Markets issue came up in that matter that was previously litigated before your board. The property owner of Arcadia Fields, Madeline Farms, the name keeps changing, but he was represented by an attorney during that entire process. What they're doing is the property owner here failed to challenge the ZBA's determination within 30 days of its approval. They're trying to reinvent the statute of limitations by now challenging the compliance order and manufacturing something with the Department of Ag and Markets to try and reverse something here. My office has also been in touch with the Department of Ag and Markets. We've sent them the entire record below so that they are aware of what's going on. I also have not heard back from the Department of Ag and Markets. But a few things I just want to get on the record. Since you made your determination in February, there was no application to the planning board for site plan review. That could have been a very simple process. We wouldn't have been here this evening. There was no adherence to the ZBA resolution. No litigation was filed. There was complete ignorance of the enforcement orders and multiple attempts by the building inspector to get the applicant to come into compliance with the code. So again, we've been here before. We've litigated these exact same issues. The applicant had an attorney. We talked about the protections under the Ag and Markets law. That has already been reviewed and considered by this board. And my July 8th letter has some really good cases in there that discuss that exact issue. One thing that was brought up about protection under Ag and Markets law, and this is likely something that Ag and Markets will take a look at if they're so inclined. In my July submission, I put in meeting minutes from December and January. In those meeting minutes, the applicant said on the record that the electricity from these solar panels, by the way, it was classified as one small array. I believe it's 3 rows of arrays without any landscaping, essentially blinding my clients. In those meeting minutes from December and January, it was noted that the electricity is going to be servicing my land, my entire property, and those are quotes. Not just the commercial horse operation that's on the site, but the entire 400 acres. the mansion, the cabin, all these other things that are not farm equipment. So we don't know if the energy being used meets that 110% of farm, servicing farm equipment. It is only deserving of ag and markets protection if it is servicing on-farm equipment. And that's 110% of on-farm equipment, not 110% of my entire property and my land. Even so, the Department of Ag and Markets and the protections in the Ag and Markets law does not give protection when there is public health and safety threats to a farm equipment. These solar arrays, since they've been installed and they remain there today with zero landscaping, we've submitted pictures that show the traffic hazards that this is causing. The glare from those solar arrays is making it incredibly difficult to pull out from my client's driveway, and even those just passing by on Route 82. In addition, I think when this was all going on, there was the utility pole that caught fire. So clearly something is going on here where this is a public health and safety welfare problem, which allows the town to preempt the preemptions of the Ag and Markets law and say that this is a health issue for the town, this is a safety issue for the town. So those are our points there. I do agree that if you remember correctly, during the ZBA process, at my client's expense, we hired Studio A Landscape Architecture and Design. They came up with several alternative locations for this. That would, one, be zoning compliant, that would be landscaped by existing vegetation, and that could be connected to the grid, and it would solve the problem. Instead of going to the planning board for site plan review, moving the solar arrays, we're still here litigating this issue before the ZBA. So the case law is clear from my July 8th submission. This is barred by the doctrine of res judicata. I suggest you confer with your counsel on that. And the ZBA doesn't have to do anything more tonight than dismiss this matter because you've already made a decision. Thank you.
Thank you. Okay.
I have a question. Enough for you. Just out of curiosity, maybe it's even off topic. Ms. Legler, I know you're familiar with the Pine Plains case. What happened there?
The Carson Power.
Yeah,
in
it's
Pine Plains.
the preserved Pine Plains.
Yeah.
Were you on that case?
Yes.
Was there a special use permit issued for a solar array in that case?
In that case,
Yeah.
yes. Not an active farm.
Was it a farm? Okay,
No.
thought it was. Thought
No.
it was under Ag and Markets.
No, not a farm.
Oh, okay.
And that was a commercial solar project. That was
Was
a
it?
large project.
Okay.
Yeah.
Thanks for clarifying that.
Oh, yeah, sure.
Right. That's the only statements we wanted to have for tonight, because it was just on for discussion, it's not on for public hearing. I took a close look at the letter and its exhibits from Ms. Legoland, and it seems to me that the issues that she has raised were before us when we originally when we did a resolution way back when. I think that the ZBA has already spoken on this subject. So I think that, as Mr. Gottlieb said, I think the doctrine of res judicata applies. That's sort of my opinion. I don't know if anybody else has any other thoughts.
I would,
Yeah, I think we did this in February. We can't change the law.
Right, all right. Well, then I would make a motion that we dismiss the appeal filed by August Madeline Fields LLC based upon the doctrine of res judicata. It's already been spoken. Do I have a second?
second.
Yeah, I don't even know if it's an appeal, but to the extent that we want to call it that,
Yeah.
I'll second that.
All right, all in favor? All right. Motion carried. Done.
Thank you.
Thanks for coming out.
Hold on, I'm sorry. Just to be, do you have the draft motion that I provided?
No.
The draft resolution?
I don't.
All right. So fortunately, I brought an extra copy.
Okay.
So I'm going to suggest we use that After you take a look at it, make sure everybody agrees with what's in it. So I would suggest reading it, asking if anybody has comment.
All right, let's see. On June 13th, 2025, August Madeline Fields filed an appeal with the ZBA challenging certain enforcement actions related to the solar panel installation on the property located at 749 Stanford Road in the town. We previously addressed the issues raised in this appeal and in our determination dated February 18, 2025, which overturned the building permit for the solar development on the project site and required planning board approval for any solar development on non-residential properties. We deemed it non-residential based upon the testimony that was given during that hearing. On February 18, 2025, the determination resolved the fundamental issues that the property at 749 Stanford Road is non-residential, which required planning board approval, overturned the permit, and required referral for necessary approvals. All arguments and evidence related to land use status, permit validity, agricultural law protection, and the use of solar energy on the property were raised or could have been raised and are precluded from relitigation before us under the principles of administrative res judicata. The only issues not decided are compliance matters like screening or the 110% rule, which the ZBA expressly declined to reach in deference to the planning board's action. That would be covered under the site plan application. On February 18, 2025, determination was based on the finding that the project site is a non-residential property, thus necessitating site plan and special use permit approval from the Town of Washington Planning Board. August Madeline did not challenge our February 18, 2025 determination in court within the required statute of limitations, and the determination has now become final and binding. The doctrine of res judicata applies to quasi-judicial determinations of administrative agencies, including municipal zoning tribunals, and precludes the relitigation of claims that were previously litigated on the merits or could have been litigated at the time. New York case law supports the application of res judicata in this context, as demonstrated in Calapai against Zoning Board of Appeals of the Village of Babylon, it's a Second Department 2008 case, and Palm Management Corporation against Goldstein, which is a Court of Appeals decision in 2008, which precludes relitigation of issues previously decided by the Zoning Board. Now, therefore, it's resolved, the appeal filed by August Madeline on June 13, 2025 is hereby dismissed on the grounds of res judicata, as the issues raised have already been adjudicated by the ZBA in its February 18, 2025 determination. The ZBA declines to entertain any further appeals from August Madeline on these matters, as they are barred from relitigation under the principles of res judicata and collateral estoppel. Now, based upon that resolution, I would make a motion that we grant that resolution. Do we have a second?
I'll second that.
Okay, all in favor? Unanimous. Okay, with that, I will prepare this final resolution, have it signed and filed with the clerk within 5 days. Anything else? I think that's it.
No.
Thank you. Okay, last one is, we have a Yadgard is back again. Area variance appeal. It's not for a public hearing. Mr. Rapplier, you filed the appeal. Why don't you come on up and tell us
Thank you.
what we're doing.
Everything we'll talk about, I believe, tonight, we haven't talked about before.
Okay.
So it all emerged. The board was last together when all the variances were granted on March 18th. All of what I'm going to relate to you this evening occurred after that.
Okay.
So Mr. Ialongo was good enough in June, forgive me, in June to send this screening plan to us. A couple of points that I think the board will remember is, number one, the pool equipment was taken out of any variance area for the benefit of the Cornells, meaning very early on it was supposed to have its own variance. And it was represented to the board in a lot of different things that it no longer needed a variance. It would be moved closer to the home. no variance was granted for the pool equipment. And even if there is a debate about coverage, no side yard variance was granted for it. So the second issue, which I believe the board will agree, the issue of screening, with due respect to the Yadgards, was not for their benefit, but for the Cornell's benefit, that the pool would be closer than they would have preferred, and therefore it would be properly screened, maybe eliminate some noise. So primarily that's what we're going to talk about. So the first document, and I can copy whatever you'd like, but these are the issues. When Mr. Ialongo sent me the screening plan, the original screening plan, I looked at it and I pointed out pretty quickly after it that there were a couple of issues. Is number one, and this was in June, the pool equipment was within the side yard, so it had been moved. And I pointed that out to Jonathan and said, there's no variance for the pool equipment where it's proposed. I thought it was going to be brought closer back to the house because it does generate some noise. It also generates exhaust because there's a heater accompanied with it. So I sent Jonathan a letter, and in the letter I basically raised three things. This was shortly after that, June 27th. And probably don't have to remind you guys because we've been here so many times, but the resolution itself, when it comes to screening, it says quite a few times that, here's an example, and this is from your resolution, the applicant has agreed to install fencing and landscaping sufficient to mitigate the potential visual and auditory impacts, of the proposed pool and the pool pump. When feasible, landscaping installations will include native species. That's repeated many times. On page 4, I didn't know what this meant, I had to look it up. It said the applicant will install curated landscaping and fencing. I'd never heard of curated landscaping before, but it says, I got this from AI, so hopefully it's correct, but in essence, curated landscaping or a curated garden means deliberately selecting, organizing, and presenting elements within a landscape, much like a museum or gallery. Curator selects and arranges exhibits. It's about creating the cohesive, aesthetically pleasing, and meaningful outdoor space. Now, I don't think, I could be wrong, but that the board, when it was talking about screening and landscaping, it was talking about purely for the benefit of the Yadgards and to the detriment of the Cornells. So, and I mentioned this numerous times, I raised another issue, which I'll conclude with, but I pointed out to Jonathan that there is no variance for the equipment to be in the side yard because of reasons already expressed, and in fact, it was represented to the board, and even it's cited by the court in its opinion that the Yadgards agreed to remove the equipment from any variance. There is no variance for the equipment to be in the side yard. So, to be sure, I pulled out the application. Now, there were two different applications the Yadgards made. They made their first, and that was the one that was premised upon the variances that were vacated for lack of notice, and then they made their second. And this is when they made the pool smaller. They took the equipment. There is no variance application in Mr. Mackey's letter or in the application itself. They also attached materials regarding a pump and a heater. I don't own a pool. I don't know a lot about pumps and heaters, but I know you need a pump. I'm not sure you need a heater. But the attachments about the pump and heater, I looked at a little bit closer today. Mainly because I wanted to understand what that could mean if you're near it. So the heater, the specs for the heater, which you can find online, in my view, discourage it being in a building. And it talks about vent termination, and it talks about how you have to construct or modify a building in order to put a heater inside a building, and that it's going to have exhaust. There's quite a bit of material in this that I would suggest believe, don't encourage the installation of pumps and heaters in buildings. The pump, the information on the pump that was disclosed, these weren't disclosed, these I found online. It talks about pump location, and it gives a number of specs for ideally where you would put a pump. One of them is in a well-ventilated location, free from excess moisture. There's a number of factors in here for where you should put a pump. I don't believe these were provided to Jonathan. I don't know, but they weren't given back to me by Jonathan. They clearly discourage putting these sorts of things in a building. I'm not saying it's impossible, but it's not in favor of it. So, I wrote to Jonathan in June. I hadn't heard much, wasn't really sure what was going on, reached out a few times. Ultimately, Jonathan replied. He copied Kyle and said, you know, you need to make a FOIL demand. I did. And I got a second permit. I got the actual building permit at that point, where Jonathan, on August 6th, granted a building permit to the Yadgards. And he attached an email about a settlement of some money, which I'll get into in a moment. But he also attached a different screening plan. Not much different, but a little bit different. And what this shows is the pool equipment has actually been placed in an existing shed closer to the Cornell, right on the Cornell boundary. There's no variance for it, and if the theory is that we moved it inside a building and therefore it doesn't need a variance, respectfully, that's incorrect. It touches the ground, and if they didn't need a variance in the first place, they wouldn't have applied for one. That doesn't disappear because you stick it in a building. And when you stick it in a building, I don't know, that building has got to be modified in order to be ventilated. And the reality is it's much closer to the Cornell's line now than it's ever been proposed to be. There's no.
Is that a new building they're proposing, Ellen?
It's an existing shed. Yep, there are 2 existing sheds there, Frank.
Okay.
It's proposed to be in one of them. Now, the tricky piece is it's hard to tell exactly what it is because the spec says filter pad. I assume that means this equipment because it disappeared from where it was before. It's not there anymore. It's actually closer to the Cornells now. And I think what was realized was, where are we going to put it? So someone came up with the idea of putting it in an existing building, which is right on the Cornell boundary, closer to their house, where it will be ventilated and where a pump will apparently be placed and a heater. Bear in mind, that means electrical, it means water, it means a lot of things going back there. So that, respectfully, this permit should be rescinded. There is nothing that came before the zoning board, or frankly until this modified map came before Jonathan Ialongo, that's in anything for which a permit could be issued. So you can't, move stuff around after it gets approved. And I know this board knows it did not grant a variance for pool equipment. I stress filter pad. I think that's where their pool equipment would tend to go. There's nowhere else on the map it's gone. So what has happened is after March, a modification was made to the plan, not to the pool itself, but to the plan. It's not on any building permit application that I've seen, and I foiled them, and it's not on the Yadgard's original application, and it's clear that that has been moved multiple times, and there is no, the ZBA has never seen it. Well, as far as I know, the ZBA has never seen this. I didn't see it until August 6th or 7th when Jonathan sent it to me. On the issue of screening, as I've said, there's multiple times, there's actually a real good reference from the chairman in the transcript. It's not in the resolution itself. The resolution, it's 6 or 7 times. In the transcript of the hearing, of the grant of the application, it says, condition number 2, and this is Chairman Retto, the applicant will agree and will do a landscaping plan and fencing for the neighboring properties to the satisfaction of the building inspector with a view of protecting any abutting properties from any view shed. And that, the spirit of that made its way into the resolution in all those locations. Now, in either plan, this is what, we had to try to create this. This is what's being proposed by the Yadgards.
Is this something they did, or?
We had to create it to
Oh.
show a 6-foot fence on the boundary. Now, that fence is right on the boundary.
Okay.
That fence destroys all of the natural vegetation that's there now, which we took a picture of. There's 4 photos.
This is looking from the Cornell's.
This is the Cornell's,
Garage?
Cornell's,
Yeah.
when you walk out of the house, you're 45 feet from there.
That's it.
And that's what they'll be looking at. And if, they have already planted trees on their side to the extent they can. In order to plant anything to eliminate that, they would have to plant it in their driveway.
This view is also from Cornell's.
Same exact view. Same exact view. Now, again, we created those. We tried to replicate a 6-foot fence on the boundary. I don't have any more, Kyle. I just have the 4. And so the board, in the variance conditions, it did give, I don't dispute that it gave the discretion to the building inspector to come up with a plan. Well, look, when I saw these things, I reached out to Mr. Yadgard's counsel directly, a gentleman I haven't met yet. He has a colleague here who I have met, a fine man, and I said, look, let's have a conversation about this. This isn't going to work. It's just going to lead to more difficulties before we go back to the ZBA. Crickets. So what I'm suggesting the board do is, and I suggested that Jonathan do this as well, is come to the site. I don't know that Jonathan ever had the chance. And it may very well be that as a building inspector, his concern is having a fence that surrounds a pool that's safe, not a fence that really protects your neighbor. What I had suggested to Jonathan was the fence should be moved into the property, leave the natural vegetation the way it is, plant some more vegetation, so when those leaves and stuff come off, which inevitably they're going to, if there's some pines, and I'm no landscape architect, but put some effort into actually screening it off from the Cornells. And if you want to screen it on your side too, that's great. You know, you'll have a beautiful landscape. But to be frank with the board, this is insult to injury. Look, we haven't agreed on these variances, I know that. But to grant all the variances and then say, go ahead and put a fence right on your neighbor's boundary. I can't call it a spike fence because it isn't tall enough, but it sure smells like one. So let me just take a look at my notes. And I have tried with the Yadgard's counsel to open up a dialogue. It is not productive. I don't need to say much more about that. I've communicated as best I can with Mr. Ialongo. He asks that foils be submitted. I understand why. Just give me one moment. And a word or two about the discretion to the building inspector is that discretion. One of the reasons I sent Jonathan the resolution, and I sent him these pieces of the transcript and the resolution to say, Jonathan, look, what it's supposed to be doing is it's really for the benefit of the Cornells. Now, I'm not looking for the Maserati, but look, what they've done is pushed this fence out as far as they can in their yard, and to catch. Look at the plan, guys. Every piece of their yard is fenced right on the edge. This is the Lears. No, this is actually our plan saying move it in 15 feet. Let me show you.
We have not seen a building department file.
So here's the building permit that was issued. Okay? This is, again, different. This is what Jonathan sent me. Here's the fence right on our boundary.
Cornell's here.
Cornell's there, yes, right. The planning is on their side of the fence. So we won't see the planning until it's over 6 feet. There's no plantings on our side of the fence, and the planting that's there now is destroyed. Here's the pool equipment, okay? Inside existing shed. first it was here, then it disappeared because there was no variance application for it. I thought they were gonna put it here. It had to be close to the pool, there's no place else to put it. They said they couldn't put it over here, but what they did was they moved it over here. I don't know if they moved it or their pool planner said you should put it over there, but this is not there now. Now, you know, this equipment and stuff, maybe there's some rakes or hose or bikes or whatever, but there isn't any pool equipment. That structure's gonna need to be modified. It's gonna need a stack on it to ventilate. You're gonna have to have plumbing, electric. Everything with this structure is going to change. So there's no variance for that. I believe there needs to be. There's also a question of whether they can use that non-conforming structure even in that way. What a suggestion might be for the fencing would be, if you can figure out the equipment, move the fencing within the property. You want to screen it with that stuff on that side, great. Just come up with a screening plan from a qualified landscape architect, let everyone take a look at it. I would invite the board to visit the site. It visited the Yadgard site so you can see what you're looking at. And then come up with a plan that's a fair plan, not a in-your-face plan, because that's what we have right now. The last issue, I don't have much information on it, was the board did require that the Yadgards pay whatever they owed within 30 days. I have to just say within 30 days, because the resolution has very clear language, and I haven't memorized it. What we received from Jonathan was that Kyle's firm had sent an invoice or invoices to Mr. Yadgard in June, and that he paid it, it looks like, within those 30 days. But the resolution of the ZBA says very clearly the ZBA can extend the deadline. I don't know that the ZBA ever extended any deadlines. I looked at your minutes, I looked at what I could see online. So whatever happened between March and June, I don't have any information on it. I have what Jonathan gave me. And what Jonathan gave me is, there's an email from Kyle sending it to Mr. Yadgard's counsel and putting him on notice that you're on the clock. And then there's an email from Mr. Yadgard. It's not proof of payment, it's an email that's saying I wired it. I assume he did. The settlement has been paid in full. I don't know what the settlement is. I assume there was some back and forth, but the ZBA, to my knowledge, never granted any extensions from when he got a bill. And the ZBA's resolution clearly said the variances are a nullity if it's not paid. So I want to bring that to the board's attention because I don't know how much you know about it either. I know what I've told you.
I was just looking quickly at the resolution. It was 30 days from when they received notification of the final fees and what those fees are due. So I guess if there was some back and forth on the amount of what the fees would be, I don't think the 30 days starts until they reached final.
It might not be. I'm raising it because I want to understand what happened.
Okay.
Right? I want to make a record of what happened. I don't know what happened. I assume what happened was that he must have gotten some bills. He didn't like them. And then they had a settlement amount that they agreed on. So my guess is the first bill he got was supposed to be the final bill. He didn't like it. So it got negotiated and there was another final bill. I just want to bring it up, make sure there's a record of it.
Okay.
Let me just check my notes, please. The primary issues, though, are the screening plan and the lack of variance for. Now, one of the things that Judge Rosa said in her opinion was that, I don't agree with any part of that opinion, particularly this part, we never raised the issue of a coverage variance for the pool equipment. What we did in the pleading, that's not the issue. That's not res judicata. This was not, I am not raising a coverage variance issue because in the papers before Judge Rosa, that equipment was not there. That equipment showed up in this very last plan.
Okay.
All right?
Makes sense.
Thank you. Do you have any questions of me?
No, I don't. Anybody else?
Not right now, no.
Well, this is not a public hearing, but I think what we'll do is the same as the last applicant. Is anybody here for
Yes.
Yadgard?
Yeah,
All
we'll
right.
all switch with you.
We'll give you an opportunity to make your statement, and then we'll decide how we want to proceed.
myself.
Yeah. Thank you.
Could you state your name for the record, please?
Yes, absolutely. William Demarest. I'm with the law firm of Brooke Fallscraft.
Okay, thanks.
Like it, we represent Daniel Gardgard, who received the building permit that's being challenged, and I appreciate the board allowing me to address you this evening. This obviously has been a long process to install a pool. It started back in May of 2022. We're 3 years in. They still don't have a pool in the ground that they can use in the middle of the summer when it's hot and the kids can't play in it, you know. And this is just, again, a more prolonging, delaying getting this into the ground. I think that's clear from council's letter emphasizing the stay on being able to move forward. That seems to be the crux, to a certain extent, of the appeal. We asked the board to, much as it did with the last application, to dismiss. We don't think that this appeal states any legal grounds that this board should consider moving forward on. To go through them, the issue with the pool equipment in the side yard. First, as it was acknowledged, this has been moved into a structure, so it doesn't require a variance. It's inside the non-conforming. Don't need a variance. That's an existing structure, so we don't think that that's a valid grounds to raise. But we would question whether a variance would even be needed at all. As was mentioned by council, the court addressed the question of whether or not the coverage for the property, the coverage variance, needed to include the pool equipment. The court analyzed that question, supported and affirmed this board's determination, and in doing so said the pool equipment doesn't fall within a structure, and so it doesn't fall within what's required to have a variance for coverage. That same determination would apply to a variance we submit, and that's already been established. It's already been determined. So even though this is a slight nuance that council's making, the fundamental argument is the same, whether or not pool equipment is subject to being a structure that would require the variance. But as said, it's been moved into a structure, non-conforming, no variance is required anyways. So we would say that doesn't support further analysis. It should be dismissed. The payment of fees, I question whether the appellant has standing really to raise that question. That would seem more a question for the town to be concerned about, whether the fees were paid or not. It seems to be that it was acknowledged that the fees have been paid, so that issue really is moot, and all indications are they were paid from when the final bill was provided. So it's really not an issue to challenge the building issuance. And then finally, the screening plan, the resolution quite clearly says that it's to the determination, satisfaction of the building inspector. That was done in this case. Building inspector made a decision. There's no requirement for the neighbor to have any say into how exactly that screening plan looks when it's placed on the Adgard's own property. That wasn't required by the resolution. Building inspector reviewed, made a determination, and so we don't think that that's a grounds for further pursuing this appeal. We think the appeal should be dismissed on that grounds as well. Even if the board decides to call a public hearing, not dismiss it this evening, we would ask that the board lift the stay that was put in place. It's been a long process. The Adgards should be able to move forward, especially as it pertains to items that were not part of the challenge. So they raised the screening plan. You know, maybe there are questions there as to that. If the board decides they want to address that issue, then okay, maybe the stay applies to construction of the screening plan. But construction of the pool itself, there's no challenge here to the pool installation, just perhaps the pool equipment and the screening plan. We would ask that the stay be lifted at least as to the pool itself, so that they can move forward with construction of the material and the equipment that is not subject to this appeal. And with that, if the board has any questions for me, I'll leave it there.
I don't have any questions. Thank you for being.
I just have one question.
Yes.
Not that this probably has anything to do with what's pertinent, but is it a white vinyl fence?
I honestly don't know the answer to that question. I was asked, I'm from the Albany
Okay.
office and was asked to come in kind of last minute. So I had not seen these mock-ups from the appellant, so
That would have bugged me if I didn't ask that question.
Yeah.
But I don't know if that's relevant at all with what we're dealing with here today. That was just my question.
Described as opaque, is one of the letters in the colleague's letter. I don't know what opaque currently means, but
Opaque is white.
that's what it says. It's called opaque.
Okay, anyway, I don't know if that has any bearing on what we're doing here tonight, but
Mr. Demarest, do you have any authority or any supporting authority that would indicate that the ZBA would have the authority to lift a stay that's automatically in place following the appeal?
Well, your code itself says that the stay can potentially be lifted under certain grounds. The building permit covers multiple aspects of the project.
Okay.
And so what I'm saying is since I think the challenge here is really a challenge to a building permit, pieces of the building permit, which is being asserted as a challenge to the entirety of the building permit, but certain parts of that permit, I would submit, have not been challenged in this appeal, and so they should be allowed to proceed on those items, which, even if we consider it, if the board were to go forward and reverse the building permit on the location of the pool equipment, the screening, then that would have to be changed, modified, but it would not impact the rest of the pool construction, and so we would submit that should be lifted and treated separately from the other items.
Thank you.
Yeah.
I'm looking at section 460, subdivision 9 of the code. It says that an appeal shall stay all proceedings, which is what Mr. Rapley's position is, unless after filing the appeal, the zoning administrator certifies to us that continuing the stay would cause imminent peril to life or property.
I agree. I don't know. That's why that's
Yes,
a question.
without that from the zoning administrator, I don't think we have any authority to consider lifting the stay that's in place with the filing of this appeal.
I agree, Chair. That's why I asked, and I've never seen a case that suggests otherwise, but
Yeah.
that's why I asked counsel if there was something I'm missing.
Right.
I don't think there's the authority.
Yeah. What do you think, guys? I think this case is a little distinguishable from what we did with the solar farm. Mr. Rappi has raised a couple of issues. I think we should consider having a public hearing next month on it. Let both sides submit their evidence, and at least that way we can have a full record and make a determination after public hearing. Anybody else have any other thoughts on that?
no, I agree. We haven't seen those new
Yeah.
site plans and whatnot.
Yeah, and actually, I would like to see a copy of the building inspector's file too, exactly what he received and stuff like that, so I would make a motion that we adjourn this matter to the September meeting to conduct a public hearing, and also ask our secretary, Lisa, to contact the building inspector and ask him to supply us with a copy of his file on the building permit application for this, copies of any correspondence or plans or anything he's received, so that we can take a look at it as well.
Okay.
Is there a second to that? All in favor?
Aye.
All right, we'll see you guys next month then.
Do you have, what's the date of September?
Uh,
I can look
I'll probably
on.
tell you.
Oh, wait, it's actually on the bottom of the agenda.
It is
Yeah, it's on.
the 16th, I think.
And would it be helpful to the board to receive what I have, what I kind of went through tonight, or a piece of that you'd like to see?
Yeah, I mean, whatever you want to submit as part of the record, you're free to do so,
I got
Mr.
it.
Rappel, yeah, for sure.
Okay. Thank you for your time.
Thank you for coming.
Thank you.
We'll see you next month.
Thank you.
All right, I think that concludes
Okay, thank you.
tonight. I make a motion that we adjourn.
Second.
All in favor?
Aye.
Motion carries. This is a long one.
Send that to the zoning board of documentation.